Hello everyone, my name is Prachi Gupta, Assistant Professor at IIMT College of Law, Greater Noida. Today my topic is sale of goods. So we will discuss what is sale and there are some sub point of this topic. What is sale of goods? Who is buyer and who is seller? Formation of contract of sale, essential element of contract of sale, effect of contract of sale, and at last remedies given to both parties. So let's begin. We are aware that every business entity runs by buying or selling commodities. In India, such sale of goods are governed by Sale of Goods Act 1930. This act has been codified as a separate enactment of law relating to sale of goods, which was contained in sections 76 to 123 of the ICA Act 1872. Though section of Contract of Act has been repealed by Sale of Good Act, this was done because provision of the Contract Act were found to be inadequate to deal with the new situation that was arising due to an increase in mercantile transaction in wake of rapid industrialization. Hence, a new law was formed to deal with the sale of goods, which incorporates various provisions of English Sale of Goods Act. However, despite the separate legislation term of Sale of Goods Act, the Contract Act continues to apply. The Contracts Act relating to the sale of goods. The Act lacks in defining some of the expression and words that otherwise define in Contract Act. In this in this PPT, I will discuss the Sale of Goods Act in detail by analyzing all important provision of case law. So now the question is, who is buyer and who is seller? According to the section 2(1) of this act, a buyer is someone who buys or has agreed to buy the goods. So there are two terms. One is who buys and another is agreed to buy. That means a person who is agreed to buy is also the buyer. And next is seller. The Act defines seller in Section 2, subclause 13. A seller is someone who sells or has agreed to sell the goods. For a sales contract came into existence, both buyers and seller must be defined by the Act. These two terms represent the two parties of the Sale of Contract Act. A key difference between the definition of buyer-seller established by the Act and the colonial meaning of the buyer and seller is that as per the Act, even the person who agrees to buy or sell is qualified as a buyer or seller. The actual transfer of goods doesn't have to take place for the identification of the two parties of the Sale of Good Act. So there is a chart in which we can see the component of the one of a component of this uh, contract. One is buyer, another is seller, and third element is good. So good is defined in section 2, subclause 7 of the Act. Goods could be existing good, future good, or there may be contingent goods. So existing goods are further divided in three categories. One is specific good, another is ascertained, and last one is unascertained goods. Every kind of movable property other than the actionable claims and money, but it includes stocks and shares and growing crops and the things attached to or forming part of the land which are agreed to be served before sale and under the contract of sale will be considered goods. As you can see, shares and stocks are also defined as goods by the Act. The term actionable claims means those claims which are eligible to be enforced and initiated by a suit or legal case. This means that those claims where an action such as recovery by the auction or suit or refund, etc., could be initiated to recover or realize the claim that is considered as goods. So next title is formation of contract of sale. So what is formation and how a contract of sale is formed? Uh, According to section 4 of the act discuss sale and agreement to sale, the terms contract of sale is a generic in nature. It tends to include both agreement to sale and sale. It formally called bargaining or sale. Subsection 3 of section 4 defines as sale and agreement of sale. The contract of sale is known as a sale where the property in products is transferred from seller to the buyer under it, thereby transferring ownership, not possession. Ownership, transferring ownership from seller to buyer. A sale can also be called an executed contract of sale. However, contract is referred to as an agreement to sale when transfer of property in goods is supposed to happen at the future date or is dependent on the fulfillment of subsequent condition. An agreement to sale may also be called an executory contract of sale. Next is absolute and conditional contract of sale. A contract of sale may be either absolute or conditional. When property is actually sold to buyer and transferred completely, it is considered absolute sale. If the parties annex condition to the contract, it is conditional. These situations could be either subsequent or preceding. When a sale is to be completed subjected to the fulfillment of a specific condition, the condition is also known as condition precedent. It is common for an auction sale of goods to include a clause stating if the purchase price is not made within a certain period of time, then the item may be resold. In this scenario, there is a real sale when property is transferred to buyer, but if transaction is not completed, the state, the seller retains the ownership of the goods. So, absolute, that means uh, the ownership transferred at that time, and conditional contract where there are some conditions which are annexed to the contract, and after fulfillment it could be before or after, both conditions are applied. So if there is any condition, then it is conditional contract of sale. What are the formalities of contract of sale? Section 5 provides uh, Section 5 provides their formalities for making a contract of sale. The following prerequisites must be met for contract to be formed. First one is the making of purchase or sale offer and acceptance of the offer. That means first is offer and another is acceptance. Second, delivery delivery arrangement for the goods and service may be immediate, simultaneously, or in installment or in future. Third one is making provision for the price paid. That means it is consideration. The fee may be paid in the fee may be paid in whole immediately or in installment over the time or all at the once. The basic requirement for a contract of sale as follows. It may be it may be in writing, it may be in word of mouth, it may be partially oral or written, it may be implied from the conduct of parties or by the course of business. The law allows for the official written instrument to be sealed in the case of government and some statutory corporation subject to the provision of any law for being enforced applies to the groups. What is the subject matter of the contract? So, the existing or future goods that is defined in section 6 of the Act. The following types of existing or future goods form a part of subject matter of the contract. The goods may be existing or whose possession will happen in future. The goods whose acquisition is dependent on the contingency where there is present sale or future. Next, next is effect of the contract. We already discussed who is buyer, seller, what is essential element for the contract of sale. And now, if once contract of sale is completed, then what is its effect? So we will discuss the effects of contract. Effects of contract: transfer of property between the seller and buyer, transfer of property in the sale of a specific ascertain goods. So there are some sub points which will discuss the effect of contract of sale. From section 19 to 22, there are different types of effects which will reflect after the completion of the contract of sale. So first one is property passes when intended to pass. According to section 19 of the act, the property only becomes transferable when both party to the contract intended to do it. Whether the stage has been reached in each case depend on the creation of the contract. Regard must be given to the contract's terms, parties' behavior, and the case circumstances in which to determine the parties' intention. So, property passes only when it is intended to pass. Second one is specific goods in a deliverable state. According to section 20, in events of the unconditional contract of sale for specific commodities in deliverable state, the property and goods passes to buyer at the period designated by the parties. When an unconditional contract of sale for particular things in a deliverable state is made, the property in goods passes to buyer at the time the contract is made. According to section 20, which also contains the first rule of determining the party's intention. Next is specific to be put in a deliverable state. So, according to section 21 of this act, it states that it is irrelevant if the price payment or time of delivery of the goods or both is delayed. Where there is an unconditional contract for sale of the specific good in deliverable form, the property and good goes to the buyer at the time the contract is made. Next is specific goods are in deliverable state, but the seller has to do something to ascertain the price. Section 22 of this act states that when there is a contract for sale of a specific good in a deliverable condition, but the seller is required to wait, measure, test, carried out another action which with regard to goods in order to determine the price, property does not transfer until the seller carries out the required action and notifies the buyers of it. At last, we will discuss the remedies available to the parties. So, there are two parties, one is seller and another is buyer. So, remedies could be availed by the buyer, another is by the seller, or there are some remedies which are available to both the buyer and seller. So, what remedies a seller have? Let's discuss. First one is seller's remedy against the buyer. There are two types of remedy which the seller has against the buyer. They are, first is suit for price. According to section 55 sub clause 1 of sale of good acts, it states two conditions. First one is that when any goods are passes to the buyer under the contract of sale and the buyer intentionally neglects payment or refuse to pay for the goods according to the terms stated in the contract, the seller may sue the buyer for the payment of the price of the goods. And the second provision states that when payment is due on a particular date, irrespective of whether or not it has been delivered or not, and buyer is neglecting the payment or refusing to pay for the goods, the seller may sue the buyer to recover the price of goods. In this case, the buyer is required to pay the seller partly in kind or partly in cash. If either of payment is not given to seller, then he has the right to sue the buyer. Subsection 1 of section 55 deals with this remedy. Next is damage for non-acceptance. Section 56 of the Act states that when a buyer is intentionally or wrongfully refused to accept the goods and pay for the same, the seller may sue the buyer for the non-acceptance of the goods. The damage is to be calculated on the basis of principle which has been given under Section 73 and 74 of ICA, that is Indian Contract Act. Section 3 of the Indian Contract Act states that when any breach of the contract happens, the parties who suffer any loss can recover the amounts from the person who breached the contract. So there are two remedies, one for price and another for damage. Next is buyer's remedy against the seller. So the buyer has three remedies against the seller for the breach of goods, breach of contract under the Sale of Goods Act. First one is damage for the non-delivery. Section 57 of the Sale of Goods Act states that if the seller is intentionally or wrongfully neglecting the delivery of goods to the customer, the customer can sue the seller for damage for non-delivery. And another is remedy for breach of warranty. In this section 59, it states that when there is a breach of warranty on the part of seller, the buyer is not entitled to reject the goods on that basis, but he may sue the seller breach of warranty uh, breach of warranty for of the price. The seller may also sue the buyer for the breach of warranty uh, in diminution or extinction of the price. Definition of the warranty is given under the section 12 subclause 3 of the Act. Section 13 states that if any condition is to be fulfilled by the seller, the buyer may consider the breach of condition as a breach of warranty. Specific performance. Section 57 of the Act said that subject to the provision mentioned under the SRA Act, in a case of breach of contract, the court may, on application by the plaintiff, direct the defendant that the contract should be performed specifically. The decree passed by the court may be unconditional or uh, according to the terms and condition as to the price, amount of damage, etc. As stated above previously, the provision which relate to the sale of goods were governed by the Contract Act. The Contract Act did not provide for this kind of remedy. The Specific Relief Act was introduced in 1877, so the equitable remedy could be made available to the aggrieved party. This section provides a solution only to the buyer. Seller cannot file an application under 58 to enforce the specific performance because this section provides no right to seller. Only on request of buyer can a specific relief be provided. And last is remedies available to both seller and buyer. The buyer and seller have two remedies while dealing with the goods under the Sale of Goods Act. These are suit for repudiation of contract before the date or anticipatory breach. Section 60 of the Act states that if any party renounces the contract before the delivery of the goods, The other party may wait till the end of delivery of goods or may treat the contract as annual and claim for the damages. Another remedies available to both the parties is interest by the way of damages and special damage. Section 62 of the Act states that the buyer or seller can recover special damage whereby loss special damages or interest may be recoverable. There is a limitation to this remedy. The parties should have contemplate that particular loss may occur if the contract is breached in any manner. And also the particular loss must have taken place after the pollution of the contract. So these are the remedies available to buyer and seller and both. At last, the act, in the conclusion, the act's main, it has, there are several points. There must be contract. In the contract, seller must be transferred or agree to transfer the buyer's property in the good. There must be a price fixed for such transfer. A sale must be made between two parties. The contract of sale may either be absolute and conditional. If the goods are present at the time of agreement, the contract is deemed to be contract of sale. For goods that are to be transferred in future, it specifically that. The essence of this act is to define the buyers and sellers' rights, liabilities, and other obligations, as well as protect against each against any breach that may occur during the course of the commercial agreement. The Act recognizes the practical significance of caveat emptor, caveat vendor, and which regulate and protect the both sellers and buyers' interests in commercial arena. Thank you.